follow strictly here today is Rodenberg versus State.
Good morning. May it please the court, I'm Robert Buchel. I represent Thomas Rodenberg, the appellant in this case. I'd ask the court to allow me to reserve 2 minutes for rebuttal.
Okay, that 15 is yours, so when it gets down to 2, you can stop if you want.
Okay, thank you for telling me.
Right.
The issue in this case relates to jury instruction regarding the federal distribution of narcotics statute, which served as predicate for the racketeering counts and the conspiracy for racketeering, as compared to the state trafficking of narcotics statute under Chapter 893. Doctors are different when it comes to prescription medication. Naturally, courts have recognized and as a part of the statute that doctors are allowed to prescribe medication when others are not. The confusion comes in this case, and the objection in this case came to how the federal distribution of narcotics statute links two requirements, and the state statute used an or instead of an and in describing what I think both parties recognize as what should be the same crime or similar crimes.
Wouldn't the use of the or, I hate using this word, behoove to your client?
No, I think the opposite, that if the state has to prove an additional element in that sense, then the state has to prove more. And particularly important in this case is because he is a doctor. This was a case supported by...
Well, is it, is it an element of the crime, or is it an affirmative defense?
Well, it's an element, it turned into an element of the crime. It's typically an affirmative defense. You're saying I had good faith and it was part of the professional practice. But as it turns out, the way the state charged it in the information, it turns out to be and was read to the jury as an element. If you look at the information, if you look at the way
At the final amended information, or one of the future? I mean, I think the fifth amended had it and the seventh didn't.
The fifth amended information appears to be the one that with the working information. Yes, confusing. There are several other co-defendants that still have not even been tried.
Okay, so the fifth was the one used in this trial.
This is the working information in this one. And so when it's laid out in that sense, it becomes an element of...
So if it is an affirmative defense, now you're arguing it's not an affirmative defense.
I'm arguing it morphed into an elements of this case based upon the information and based upon how the jury instructions were given.
So if it is an affirmative defense, and if it's an or, doesn't that give you 2 shots? If you prove either one, you could prevail?
The state is not reading it the same way, and it is confusing. If they have to prove or that it either you were outside of your profession and you had bad faith, yes, then as an affirmative defense, it's helpful to Dr. Rodenberg. But what we have here is that it was put in as an affirmative defense. The state must prove this, or this, and it conflicted with the federal distribution statute, which is...
Well, there could be a circumstance where, let's say, it's not within the professional practice, but he acted in good faith. So in other words, he rendered assistance to somebody, and it turns out that either should not have done it because of either the contours of his practice, or so he'd have an opportunity to rely on that as an affirmative defense. But isn't it true that it wasn't objected to, so we have to look at this from fundamental error?
I think I'll answer your second question first. I believe it was preserved in the discussion regarding and on the transcript between 2834 and 2857. There was the judge specifically stated there's long conversations over several days about jury instructions. The trial judge said, hey, all your objections that you made yesterday are made today. You don't have to keep objecting. You don't have to do any of that. This is where the objection is preserved. And as to examples of how one could be within, not in bad faith, but outside of the question of the practice, that's negligence, isn't it? I mean, it's civil negligence, and that's exactly what we're trying to avoid. Other examples could be if a doctor were to give his neighbor a medication in his garage.
But you're not attacking the whether or not there's sufficient evidence to sustain it. It's just a question of the jury instruction.
Correct. I mean, there was, we did not attack as in terms of judgment of acquittal, if that's what you're asking.
Correct.
So,
Well, outside of professional practice, does the state, and I'll ask the state the same question, are they arguing that this was outside of the appellant's professional practice?
the state certainly is saying overprescribing oxycodone is both elements.
Notwithstanding, he did it. I mean, it was all in the clinic. Patients coming to him in the clinic,
Right.
writing on clinic prescription pads.
Sure.
Okay, well, I'll explore that more with the state.
The key, I believe, is that the civil versus the criminal liability. Now, there was an instruction that the court gave, but I don't believe that it went far enough, and that if we look at the certain federal cases and certain state cases, there appears to be confusion about whether there should be an and or an or. I mean, even reading it, the state reads a certain case differently than even I read the case, but in this court, in dictum, in a case called Denarny, which is cited in the brief, a practitioner, it is the act of prescribing the controlled substance in bad faith that subjects the physician to criminal prosecution. This is so regardless of whether the prescription is filled. Thus, the physician who has issued a prescription for a drug in bad faith and not in the course of his professional practice has done everything he can towards committing the crime. And so the dispute is over whether this overmedication of oxycodone and other painkillers is truly, is it just negligence? Is it a philosophical medical thing, like certain doctors believe that there should be more pain medication and some less?
Well, there is evidence in this record that would go to consciousness of guilt. I mean, it seems to me, although like you said, you don't argue JOA, when the owner of the clinic says we asked for an MRI because it quote makes us look like we're not dirty, and the appellant is supposed to saying, I don't know what you're talking about, or get out of here, or we don't do it that way, says something, but they have to pay for it. That clearly shows at least some type of consciousness of guilt.
It was evidence. It was overheard, and Dr. Rodenberg didn't respond.
In the record that we have to accept here, and also I think goes to the witness Scott Utz, Gregory Martin, where apparently he said he had no pain. The MRI showed no abnormalities, and he still prescribed 160 OxyContin 30 milligram tablets. So this is not a situation where it's purely, which they can, and you could have a case where they're just purely doing it based on prescriptions within the context of a practice. That doesn't. I mean that puts a different spin on what. I mean, it's not your typical overprescribing case.
I think when you're talking about the undercover agents that came in, you have something unique going on. You have someone that's pretending to be in pain, but really not. And they even say in their testimony that, we got to say enough so they don't know we're a cop,
Correct.
But at the same time, we got to try and walk the line to induce or see if the doctor will prescribe. And that of course is all subject to factual debate in front of a jury. To say, to mark on a form that you have number 5, out of 10 when you're on medication, and without it you're a 9 or a 10. These are things that are they're representing that they're in pain. Plus the fact there's some evidence in the record that says, some of them, at least one of them, undercovers was kicked out. He went too far and said something that didn't make any sense, and his MRI didn't indicate anything. So I'm not having the factual debate. in terms of judgment of acquittal. But I think when there's conflicting, when the federal, one of the RICO predicates is the federal distribution statute, it says it a different way, the two elements. It's what said is knowing and intentionally distributed or dispensed oxycodone, a Schedule II controlled substance, or any mixture containing it outside the usual course of medical practice and for other than legitimate medical purposes. And I think the confusion in the jury instructions when your defense is I'm a doctor and I was doing my best permeates the whole deliberations and permeates
Wasn't
the
it
whole.
also, I mean, the predicate acts of the racketeering were not the trafficking in the 893 group, or you?
There were several predicate acts. They were pled in the alternative. There was no interrogatory verdict. An interrogatory verdict was requested, and so the argument now is that we don't know which predicate act the jury found Dr. Rodenberg guilty beyond a reasonable doubt. So if there's a problem with one predicate act, like if the instruction was wrong, then we don't know. Had there been interrogatories, perhaps we'd have more clarity upon that.
Let me ask you this. I'm still hung up on the preservation issue. I mean, your opponent argues that in this case, your client specifically asked for the instruction containing the language to which he now objects, and he also affirmatively indicated, so says your opponent, that the language was fine when asked by the court. So tell me about that.
It's accurate on the record. I just believe that when we get into the discussions over time over jury instructions, and I found it right here. It's on page 2857. So this is prior, I believe. The court is saying, may I also make it very clear for the record, all objections to the instructions made by defense yesterday, made today, and made at the charge conference 2 weeks ago are preserved as if made at this time and are not waived. So when a trial judge kind of gives you the stop, you don't have to keep doing that.
Gotcha.
I think it's preserved. We also made fundamental error arguments as well, that if it's truly permeating the discussions and jury deliberations, that it's something that would entitle Dr. Rodenberg for a new trial. I'll reserve the rest of my time.
Great,
Thank you.
thanks.
Good morning. May it please the court. I'm Linda Moyer on behalf of the state of Florida.
Can we talk about that, Ms. Miller, that first issue? I mean, your opponent says right there on page 2857, there is a clear objection made for prior, for future, for any kind of objections that might be made as to the jury instructions.
Oh, I would be delighted to answer that.
Please.
There was never an objection made at any time during the discussion that for which the defense specifically said we cannot use or we need to use and. Your Honor, that is inaccurate. We need to never, ever. And in fact, and I want to be very clear about this, I've cited 6 places on the record where our argument is that he has waived this issue completely. There is no fundamental error analysis because this error was invited. And I rely on my brief with regard to all 6 of those instances, and I'd be happy to elaborate on them. But I would like to point to one of mine that may have been kind of caught up in the flow of discussion, and that is, in the original information and the amended information that's part of the record, you will see that we did not use this particular language from 89305 at all in our information as part of the elements. That is because it is an affirmative defense.
Is it the 5th amended or the 7th amended it's used?
It does appear that they're looking at the 5th, although the 7th amendment is part of the record, and I don't know which one went back with the jury. Your Honor, I did catch your first question with regard to the language in them, and I'd also like to point out, since you've asked this, I'm looking at page 232 of the record myself right now. That's the 5th Amendment, and going through the predicate acts, and the word "or" is inserted with regard to 89305 each and every time. Good faith or or not in good faith and not or not in course.
Okay, but I guess the issue is if it's in the, or could have been in the information given to the jury, then the state has adopted that as being an element as opposed to an affirmative defense.
This is first of all, again, we have a Seventh Amendment information. Secondly, what I just said is in the Fifth Amendment, the word "or" is in the information as well as in the instructions. The only place that there's an "and" is with regard to the federal predicate act.
If we don't have interrogatories, how do we know what the jury convicted of?
And we have federal case law going back to U.S. v. Moore. And not only did U.S. v. Moore, the United States Supreme Court, say that the only element that the state needs to show is outside the course of professional practice, but there have been a slew of cases, federal cases, many of them 11th Circuit and 5th Circuit cases that is specifically held that that is all that is required, and that doing instructions in the disjunctive, even when the information in those cases was in the conjunctive, is not error.
So your argument is even if it's an element that whether you accept it or not, you still all have to show that it's either or.
Or, because to raise, it makes complete common sense. To raise the defense, I need to show that I acted both in good faith and in the course of my professional practice. But if I am the state, if I show that you didn't do one of those two things, your defense doesn't apply anymore, and therefore I've showed that you violated that defense, and therefore I can prosecute you for trafficking.
But this comes back to what the statute's saying, and in
The statute which sets, it's the 89305, which sets out the affirmative defense to the delivery charges in 893.13 and 893.135, that's a trafficking offense, uses the word "and." So if I'm making an element of my offense,
It
if
really
I show...
depends on whose ox is being gored. If it's the state proving it, then they have to show that "and" did not, the defense
No,
has to
you show
show
"or."
they have to do both, and the state only has to show that one of the two doesn't apply for the defense not to be able to rely on what they have to show both elements.
Exactly. With regard to going back to the waiving, we originally did not include this language at all. And I can't discern exactly what happened, but on page 608 of the record, in the state's second, in page 353 of the record, the state says in its motion in limine that it indicates that the information should, that the defense instruction, an affirmative defense instruction, should track the statute's language, 89305. We get to the state's second motion in limine, which is on page 608, and it explains to the court that it has now, the good faith defense has been incorporated in the instructions on delivery, etc., pursuant to the defendant's request in the omnibus motion to dismiss and exclude. I look at the record and I see on page 398 of the record that on January 6th, early on, there was an order on the defense omnibus motion, but in our record we do not have the defense motion to dismiss. Apparently, I discern and I believe that the record is sufficient on this point, and I'd be happy to supplement if you would like me to do so. But what the state's point is that it had originally charged it so that the defendant needed to raise his affirmative defense, which is the traditional way of doing it. But then at the behest of the defense and after negotiations, they included this information. So we went from, let's track the statute specifically word for word and make it a defense, to, well, we want it this way. And then we have a number of times where they're saying it's fine. And in fact, even in closing argument, defense counsel gets up there and says, this is what the instructions are going to be, and uses the "or." So not only do we not have an objection, we've asked to do away with using it as affirmative defense and specifically tracking the language of the statute. Now we've incorporated as element, which increases the state's burden and relieves the defendant of any burden in production.
Saying, but it seems to me that if we assume that it becomes an element of the crime because it is part of amended 5, which we have no reason not to know, it's in front of the jury, that the trial court should have granted the interrogatory, we wouldn't be discussing this issue right here,
I'm not
right
even
now.
really, I'm not even sure who requested the special interrogatory. But I don't want there to be any confusion. The only time in the Fifth Amendment information that the word "and" is used is with regard to the federal statute.
But the federal statute, I mean, usually, when you have an element and it says "and," you have to prove both. I mean, that's just, standard law. And if the state puts that statute in there and affirmatively puts it, they accept that responsibility. And, we can argue whether or not the shifting burdens and common sense, but ultimately, when the state puts it in there, they got to prove it. And if we don't know which one of the predicate acts that they relied on, because the trial court denied the request for an interrogatory, it just seems it complicated a case that ought not been.
It may have complicated the case, Your Honor, but I disagree with regard to it becomes error. It certainly doesn't in this, because if this panel does not decide that this was affirmatively waived and invited, then we go to the next step, which means that the appellant has to show fundamental error. Can't. This is not an essential element of the offense. We know that it's not an essential element of the offense because the United States Supreme Court said in U.S. v. Moore that you only need to show the one element, which is to do it outside the course of professional practice. And of course, we have case law that says that this is an affirmative defense, which means that it's not really a material, which is what we look at for fundamental error, whether or not it goes to a material element. It doesn't go to a material element. It goes to an affirmative defense for which we've relieved the defendant of the burden of showing. And I have just a number. I'm going to just stress that we've cited Dilio, which is an 11th Circuit 2015 case, Armstrong, Nelson, Merrill, Joseph, and I believe Tobin, all from, Nelson is from the 10th Circuit, all that are to that effect, that it really is an affirmative defense. It's not a material element. It doesn't matter even if the indictment in those cases was in the conjunctive. You can do it. It's not plain error to do it in the disjunctive. It's not that Florida law says anything different. In the Weeks case, they cited U.S. v. Moore, and they said, well, Moore established what the good faith is test, and they said that Moore said basically that good faith is when it falls outside of the usual course of professional practice. With regard to the Noreen case that's been referenced a number of times by defense counsel, that is a 4th DCA case, and it did nothing more than to cite to an early second, I believe it's a 2nd DCA case, Vinson, and quoted language from Vinson, where Vinson says, well, you know what, if the state has shown both a lack of good faith and committing the offense outside the course of professional practice, then it's done everything it can do to prove this offense. And that's the language that was relied on in Dear Noreen. And so, while I admit that they speak of bad faith in there, we have Cliento, a Florida Supreme Court case that speaks of what our burden is to show is bad faith or outside of the doctor's professional course of practice.
Now, how is that fleshed out, that second term, outside the scope of his professional practice? Because the undercover agents came to his practice. It was, as defense counsel said, it wasn't in his garage. He wasn't using fake prescription pads or anything like that.
That's correct, Your Honor. But he was not conducting himself in a manner that is accepted as good professional or professional practice, and that was established because we presented the testimony of not only an expert, Dr. Reuben Hope, who said as much, but we also presented the DEA, Kyle Wright, who was the investigator with DEA that spoke about average ordering information and how I believe it was 96% of the defendant's prescriptions were for oxycodone, and that 2009 to 2010 period. And that while he was prescribing 295,000 dosage units, the average was 24,000. We're showing that he's like really outside.
Are those all related to the practice or to the doctor himself?
It's related to the doctor.
To the appellant.
To the doctor. That is correct. And we also have the testimony of Dr. Mark Kukerman, who was another physician who was there. Yes, he took a deal, but his testimony still goes to the sufficiency of the evidence. And he was saying this is a cash-only business, no insurance. They didn't want the scrutiny of the insurance companies. He said that he got his job through Craigslist. He's not even sure that they looked at his CV. The money was fabulous. He made twice as much as he normally did, and that what the principle at that practice was to keep the people happy. When he was asked on page 1206, what does that mean? He says, give them what they want, and what they want is narcotics. And
were the doctors that sold more or prescribed more drugs paid more by the practice?
Well, I'm not exactly sure. Now, the testimony that they came on, he said that they were paid both in cash and in checks. Patients are paying in cash. I can't say specifically how he got the cash. I know there was stressing throughout the trial that this defendant only made $150,000 for a certain period of time, but that was just what was on the record. And I can't really elaborate on exactly what the practice was on how to pay them and what the combination was, if there was a combination. So the state's position continues to be that it doesn't matter under what standard, that if you look at this case, that you will see that this instruction was invited and that the defendant has waived any argument with regard to the instruction, that otherwise he has not established fundamental error, that that this is really an affirmative defense, and that the manner of doing it is to do it in the disjunctive, and that
And even if it's an element, you say you still.
even on the predicate that's under federal case law, interpreting that exact statute, which, by the way, I just want to make this clear too. With regard to the federal statute is 21 U.S.C. 841, and that's the delivery and trafficking statute. That language that they're referring to must be issued for a legitimate medical purpose by a practitioner acting in the usual course of his professional practice, doesn't have an and in it, and comes from the federal regulation with regard to the statute. The regulation is 21 CFR 1306.04. And so we're really talking about a regulation applying to an affirmative defense or creating an affirmative defense to the federal statute. Thank you for your time. We ask you to affirm.
Thank you. The conversion of an affirmative defense into becoming elements of the charge in the information changes the nature of the error in this case. The plain language of the information and the plain language of the jury instructions supporting the information make the affirmative defense, what typically would be an affirmative defense, now elements of this case, and that changes everything. I do want to say, yes, Dr. Rodenberg was an independent contractor. He didn't own it. I have $155,000. He worked in and out of the clinic over a period of 2 years. There are conflicting federal statutes as well. I cite it, United States versus Rogers, also using the legitimate medical purpose and in the usual course of his medical practice. United States versus Rosen in the Fifth Circuit as well uses the same language, and a Ninth Circuit case, United States versus Larson, all cited in the brief as well. The DeLeo opinion that the state is relying upon is an unpublished opinion by the 11th Circuit. Even the 11th Circuit wouldn't rely on it, but it does say what the state represented. It is confusing, and I believe that plain language is the key to why Dr. Rodenberg's jury instructions were error, and even fundamental error. To suggest that, and Judge Levinson at the trial level gives his jury instructions before a closing argument instead of after, and so to have a lawyer who embraces the jury instructions, it shouldn't be considered waiver by this court. These are the instructions. You might as well argue to the jury what the instructions, what they were just read is the law, because for purposes of the case, it is the law. We ask you to reverse and remand for a new trial. Thank you.
Okay, folks, thanks. All right, the next one up is Cheryl Robinson versus State.